Here's one for you. What do music, movies, and games have in common? I'm sure you're quick to say that they're all some form of entertainment, but let's go a bit deeper. All of these things would most likely be copyrighted. Confused? Attorney Veronique Evans explains.
Copyright is the law's way of protecting authors of work from having their works used without their permission. So what happens is that you would register your copyright, because once you create something, once you create a work, you have the copyright. So it's just a matter of you registering that copyright so that the world knows that this is what you've done.
Now, I'm sure you realize by now that copyright is not confined to written material.
It covers books, poems, music, artworks. It covers sculptures. So basically anything that you create can be covered by a copyright.
So just how does the whole copyright process work?
First of all, you need to find out who your defendant is, who is actually doing this, who is creating it, or who is promoting it, or who is actually putting your work out there. And then once you've identified your defendant, then you would bring an action in the Supreme Court for copyright infringement. You would then provide a copy to the Copyright Registry along with the requisite form. Now, the form will depend on what type of work it actually is. So, for example, if you have a music, the form for a piece of music would not be the same as a form for a book. So depending on what you have, you would put in the requisite form along with the fee and a copy. Now, when you register, it depends really on if your work is published or if your work is unpublished. If your work is published, then you would have to put in 2 copies of the best version of the work, of the publication. If it's unpublished, then you put in 1. And then you would do that, and that would be registered in the Copyright Registry so that persons could then go and say, okay, this is copyrighted.
Ms. Evans also explained what remedies are available if a person is successful in their claim to the court.
There are a number of remedies that you can get. You can get damages. For example, if the use has caused you loss, then you can get damages. There's also statutory damages that can be gotten. So that means that once the infringement is shown, the damages will naturally follow. So your damages would be over and above that. You can also get injunctions to restrain persons from using the work.
So until next week, I'm Sasha Lightbourne, and now you know you're right.